Okay, I've gotten more of you, so that's good. Thank you for coming. Um, we'll get started right away. I just wanted to kind of remind you guys in terms of the just kind of where we're going with these new contract trainings. We're trying to really focus on those that are already in production, though we are really encouraging brand new agents to still obviously come. Um, interest in terms of like hearing other people's questions. I would love to have a lot more discussion around these topics from our seasoned agents. Just in the sense too of like how much you can learn from hearing other people's questions. Um, and I also want to say that I anticipate that these trainings will be shorter than the previous contract trainings that we've had. Just, again, more so because we were so like contract heavy, really like going line by line in those contracts. So I don't expect us to be longer than a half an hour. Um, and again, I just always encourage lots of questions and discussion around what we're focusing on. So today we're kind of just in general talking about staying in our lane when it comes to legal advice, where our guidance needs to stop with our clients. Because as it is said over and over and over again in our contracts, we are not attorneys and we cannot give legal advice. So, with that, just generally speaking, with the forms and form use, so this should be I mean, well, all of this should be just recalls to our like even to our licensing, but this is one point that I know that in our pre-licensing coursework was driven home in terms of what we can do with the forms themselves. So a Wisconsin licensee cannot or we may, excuse me, cross out provisions on approved forms to reflect the agreement of the parties, provided the deleted language remains legible. So we cannot physically block anything out, but we can just do a simple strike through so that we can see what the language was behind it. Um, we are able to modify the forms to meet the intent of the parties. However, when additional verbiage is needed, we must use that additional provisions sections. So there are lines provided at the last page of the addendum A, and of course the offer itself. So if you do need to add additional language, we're going to use those additional provisional lines. I see Emily is on here. We just did that this morning for an offer where we needed to, we couldn't fit language in a space, so we used the additional provisions to make sure that our intent and the description of what we needed was crystal clear. So we do see sometimes that if someone's going to cross something out, that they want to just like write above it. We cannot do that. Again, if you need to change or just like rewrite a piece of what the contract says, then we need to use that additional provisional lines. In terms of giving explanations of the forms and the provisions themselves, we are obviously, of course, able to provide a general explanation of the provision, but we cannot make statements about the legal rights of the parties as it relates to the language itself. Um, Agents can also help parties by completing approved forms, again, according to the instruction of the party, drafting addenda or additional provisions, and providing, again, general explanations of the contract sections. I've got to move my box here. And then the clause library in our zip forms. So, and I can show you guys this at the end. Um, But we do have a library of clauses that our attorney has drafted for us, and depending on your need, there could be a clause for it already. So I'm highly encouraging our agents to just like look through that forms library. There's about 22 there, and I can show you again where it is at the end of the training. But that's already pre-printed language that our attorney has drafted for us. So, um, moving on. And this is kind of a weird one. So this was, I was re-reminded that this is a part of our statute. So we cannot prohibit any client from retaining an attorney. So, it might be the case where there are people out there saying, you don't need to consult an attorney on this. Absolutely, if a client has expressed their desire to, we are absolutely encouraging them to use an attorney if they want. And we can encourage them to consult their own attorneys with any legal questions they have. Obviously, there's again many, many checkpoints throughout our forms by design to make sure that we're touching on this with our clients, that they can, again, consult their own attorney if they have any questions about what they're signing. Um, Attorneys, again, can offer legal advice to their clients and outline many of the legal impacts of each provision in the contracts. And while all WRA and statewide forms are reviewed by attorneys, that does not mean a party does not need one. So, um, there are, it's pretty rare, I would say, that a client uses an attorney to review an offer prior to its submission. Usually what's happening is if an attorney is getting involved, it's when there is a dispute along the way between that accepted offer and closing, or obviously post-closing, right? Um, but if a client wants to have an attorney review an offer prior to our submission of it, obviously they have the right to have that opportunity. We just don't see that as much here. But again, obviously, if they have a desire, there are some clients who will come to us, proactively and state, I've want my attorney to review this prior to submission. Um, so, all right, our roles around material adverse facts. So as listing agents, again, we have a duty to walk around the property and disclose any material adverse facts that are inconsistent with the real estate condition report. So, um, again, this is at the time of your listing the property. So, you might be having this walkthrough at the time of the listing, at the listing appointment, even prior to execution of a listing contract. And you're going to be taking notes on the property. You're going to be pointing out what you see and what you observe to the client as you're walking through, assuming you're having an opportunity to walk through with the client themselves. But you're going to use that information to either talk to the seller after you review their real estate condition report. Anything that's inconsistent with what they're saying, you can either point that back to them and highlight, hey, I did observe this as well. This might be something that you would want to disclose. Or Mr. Seller, if you're not going to adjust the real estate condition report, then I will need to put it on a material adverse facts form myself and provide that information myself to the parties in the transaction or potential parties in the transaction. Um, One thing of note when you are filling out a material adverse facts form, that you are simply listing the observations, but stopping short of making any inferences or giving an opinion about what you see. So, again, if you see like a water stain on a ceiling, you're simply just going to observe and write down what you have seen. Water stain on ceiling in kitchen. You're not going to give an opinion about, oh, this could maybe have come from a leak in the shower, or this could be a leak from the roof. You don't know that information. You're just simply stating what you have observed. And then, of course, when it comes to the real estate condition report, we can't advise on what is a defect or what is not. But my mantra always is to disclose, disclose, disclose. So, if a client has a question about what they should or should not say, I'm just saying all information is good information. The more you disclose, the better. I am very much of the opinion that if there was a major issue that had happened with the home, and it was corrected, that is good information to have as well, for that potential homeowner. They would want to know if there was something, a major repair happened on the home, prior to their ownership. So, um, while it's not required, again, I'm just kind of leaving it as that blanket statement, disclose, disclose, disclose. Um, you know, Even if there was something that major that had happened, you could describe what happened and how you fixed it. So, from the buyer agent perspective, when it comes to disclosing material adverse facts, buyer agents must walk through the property and examine the condition of the property, of course, when they are um, showing the home. Um, so, you're going to be pointing out these things to the buyer, but kind of the same idea in terms of, you know, instead of making any inferences or opinions about what you see, that could help inform how you go to write the offer. So if that water stain on the ceiling was something, Mr. Buyer, I would advise that we could have this checked out ahead of time. We could rely on the inspector to look at it as well. We could also call for a follow-up inspection or an independent inspection of that right off the bat in the offer to purchase. Um, but what we cannot do is, if this is something that we don't see on the real estate condition report, we can't give legal advice on a buyer's rights if they end up purchasing the property on whether or not the seller had prior knowledge of this. So, whenever I'm seeing something in a home that I think needs to be looked at, I'm asking the buyer, is this something that you would want to see addressed in the offer to purchase right off the bat? Because there is the opportunity for that when you are looking at the home prior to submitting an offer. Hopefully this is all making sense. And then as it relates to title policies and deeds, so we cannot give advice or opinions on how to hold a title, which kind of deed to use to transfer or receive title. Again, we have to point them back to an attorney if there are questions on that. We cannot give advice on potential resolutions to conflicts over property lines or encroachments. And again, back to that real estate condition report, we cannot give advice on which property conditions a party should disclose. Again, if they do have questions about those things, we need to point them back to an attorney. So the statute itself, reads licensees cannot provide advice or opinions concerning the legal rights or obligations of parties to a transaction. Agents should not be giving parties any legal advice at any point in the transaction, of course. And if an agent does provide legal advice to a party intentionally or unintentionally, they can face serious consequences. So first and foremost, it is a code of ethics violation. If they are a realtor member, so Article 13 of the code says that a realtor cannot engage in activities that constitute the unauthorized practice of the law and should always recommend that legal counsel be obtained. If someone has been found to violate the code, they could be required to enroll in further continuing education, receive a letter of reprimand, or potentially have to pay a fine. If an agent violates the regulation, they could face a fine, a license suspension, or depending on the severity, could potentially lose their license altogether. A party to the transaction could sue the agent for damages related to the unauthorized practice of law as well. And then, of course, a firm could terminate an agent's association with the firm for engaging in the unauthorized practice of law. So it's serious. And that's why, again, there are many, many warnings about it in our forms. So it's something we have to take seriously. So the legal hotline, I encourage our agents to use the WRA legal hotline. One resource I didn't even put on here was our hotline in general, um, which I can show you guys the number again. But whenever there's anything that even the compliance team has trouble answering, we could refer you guys to the hotline itself. There are all of these transactions, something new comes up every day. And depending on what the question is, either that's something we could take on ourselves and call. But we also want you guys to have your own agency around these questions and hear it directly from the source being the WRA, yourselves as well. And so, having us ask you to call the WRA legal hotline directly, may be the case, and maybe more often the case. The WRA legal hot tips. So when you go to WRA.org, and you search for the legal hot tips library, there are so many times, countless times that I have just come straight to the legal hot tips when I have received a question from an agent. Um, when we come into these roles, we've got to do our own research ourselves in terms of fielding some of these questions. We don't have kind of like a formal training. So it's like, we're also consulting the legal hot tips in the WRA constantly. Um, you know, for all of us, I can say it's safe to say that, like, now that we've all been in our roles for a number of years, having to consult the hot tips is not as needed. But, again, as questions come up that we don't know how to answer or did not know how to answer at the time, coming straight to the legal hot tips was the first place that I would go personally. I know the others as well. So I just really encourage you guys, whenever you have a question, just to go straight to the legal hot tips as well. And you more often than not, you're going to find the answer that the same question that you have, somebody else had before you. So, um, the GMAR, this, the Greater Milwaukee Association of Realtors, we used to have a heavier hand in more of agent to agent disputes. They might also field client calls as well. Um, More so, what I would want you guys to use the GMAR for is to call upon the Code of Ethics and really learn the Code of Ethics, which is supplied through that GMAR website. Um, but they are a resource that sometimes that we will need to call upon as well. And then the compliance team, of course. I guess where I didn't write down was the number, which I will give to you guys again. But we're kind of your line of defense. Um, Mostly, I would say in post-close issues, but then during the transaction as well, if there is anything, if a client is questioning something, if a client is wanting to get out of a contract, that's another piece of this where we need to uphold the contract. We cannot look for ways that a client can get out of a contract. So that happens a lot, where a buyer gets cold feet. And, we can work through our contingency items. And if it were to naturally fall apart through one of the contingency items, fantastic. But if they're looking to quote unquote get out of a contract, and not through the ways of the contingencies, then we have to point them back to an attorney. That is definitely um, encroaching on legal advice. And I'm constantly telling our agents, again, we need to remind the client that our job is to push the contract forward and see the contract through and guide our clients through the contract that way. We are not ever in a we would never be in a position where we can um, quote unquote get them out of a contract. Um, and during those conversations, I'm just going to recall one last week. One of our newer agents from a transitioning agent, so she's a seasoned agent from another company, but new to us. She had a client who just flat out said, "We do not want to close on this house. It's too small for us. We've changed our mind." And behind the scenes was trying to look for ways to get out through their financing contingency. If they are behaving in a way where they're trying to get out themselves, we just need to keep re-reminding them that they need to consult an attorney, um, and having conversations with their lenders, etc. Lenders have their own code of ethics that they must abide to. And they cannot lie for a client either and state that, that financing was rejected because a client asked them to. So they cannot lie either. So again, I just really want everyone to have an understanding like of our role as it relates to the contract and when a buyer gets cold feet as well. Um, and then just what the compliance team is really here for as well in terms of, you know, explaining the provisions in a way to the client to kind of help them understand, um, you know, the consequences if they were not to see something through, the consequences of a failed deadline or a past deadline, missed deadline. We harped on the uh, financing contingency a lot last week, in terms of what happens when there's a missed deadline there. So, we want you guys to be able to put these, be able to explain it to the client in a way, that would be helpful to you. So, I definitely see that as a big part of our role in terms of, so much of it is not necessarily um, giving legal advice, just explaining the provision itself. So, and why we do our contract trainings as well, just because, until we get to these scenarios, we might not have an understanding ourselves. And I'm always pointing back to the inspection deadline, right to cure, for example. If that never pops up, then it's not something that we might be familiar with and can like spew it off pretty easily on what happens with right to cure, right? So, more so again, your compliance team is there to help you verbalize to the client what, how the provision reads, should an issue arise. But back to explaining our contracts and giving general explanations of our contracts. That's definitely something that, I want you guys to have the ability to have your kind of one-liner about um, what that section reads. So, it's of course unrealistic to like read a contract line by line to a client, of course, when you're going over an offer. But you do need to be able to explain the section in one or two sentences. So, I definitely implore you guys to just, if you need something to work on that, you know? Um, okay, I'm gonna stop the screen. Oh, there's more of you than I thought. I would love questions. It's 12:25. Actually, I'm gonna keep going. Another point I wanted to make is around our staff attorney. So, via your compliance team, we do have access to a staff attorney. But it's really important to understand that our attorney is for the brokerage, not for the clients. So we do always need to point a client and a customer back to their own attorney for their own advice. But if there are some wonky things that, that we just don't have an understanding of, we'll definitely use our attorney. But it's not something that because the client has retained us, or has contracted with us to represent them, that they have this access to an attorney for our attorney to speak to them directly, if that makes sense. So our attorney is never talking with our clients directly, at all. So I just want I want you guys to have an understanding of that, because there is a misconception sometimes that, because we have a seller client, that seller client can use our attorney to ask questions, and that's just not the case. Um, okay, are there any questions, any scenarios you guys want to bring up? Okay. Well, next week is family reunion, and I think a lot of our agents will be in family reunion, so we're just going to do a Q&A next week. So either Ashley or I will be on to answer any just general questions that you might have, but obviously the compliance helpline is always there. And actually, I'm going to go back to sharing. I want to make sure. Yes, there's the phone number. So 414-368-9359. So again, you guys all have your own individual compliance brokers that you would be calling upon, or using if there's an escalated situation. But this is always going to be your first and foremost line of offense in terms of a question. We all man this, and I'll tell you guys, we're all talking to each other all of the time. So, if there is a question that somebody has that we don't necessarily know how to answer, or like, hey, this is an odd one. We've got like our mass text that we're like speaking to each other through as well. So, um, okay, well, I'll let you guys go then.